Hello again, everybody. My name is Jason Hanford. I'm an attorney at Chartwell Law, and I'm here today to do another one of our informational videos. We've done a series of these since the COVID restrictions and shutdowns started, and our library is growing. So hopefully you've enjoyed one or two of them. You're welcome to share them on social media, put your feedback in the comments, nice comments only, as always. Mean comments, I suppose you can email to us. But we're doing this, just to put some information out there for our friends and for our clients. So if you have any questions, you can certainly email myself or my partner, Lori DePolis, who's going to be on today. You can go to the Chartwell Law website, which is chartwelllaw.com, and look us up. Or if you have any other needs in other areas of the law, you can certainly look there. We're always happy to talk with clients or anybody really within our industry and other industries. We hope everybody's doing well, everybody's safe and healthy. It's been a wild, I guess, 4 months or so, but everybody's doing as well as they can. We hope you're okay out there. So with all the heavy stuff out of the way, I'd like to introduce my partner, Lori DePolis. Lori, can you say hi to everybody?
Hi, everyone. Hope everyone's doing well. I'm, like Jason said, I'm a partner at Chartwell Law. I've been doing workers' comp insurance defense for approximately 15 years. I'm happy to be here to discuss Commonwealth Court case.
Yeah, so Lori's Commonwealth. She's a workers' compensation attorney, as am I. We're not here to talk about COVID-19. So if you wanted another COVID-19 video, you're gonna have to wait. We're here to talk about the exciting world of Pennsylvania workers' compensation and fee agreements. Sounds a little dry, but I think this decision, it has a little bit of a long-lasting impact that we might be dealing with it for a while. It's an interesting Commonwealth Court decision. Today, Lori, we're talking about Nevis versus WCAB. It's a decision that I believe came out in May. Can you tell everybody what was the initial judge faced with in that case? What was the dispute? What happened?
The dispute arose from a penalty and review petition. Originally, a claim petition was filed and a judge approved a fee agreement between claimant and counsel. In the fee agreement, there was a provision that counsel would be entitled to 20% of any medical benefits in addition to indemnity benefits that was awarded to the claimant. So the fee agreement had been approved in a claim petition proceeding. The case eventually resolved via CNR agreement. There were some outstanding medical bills. One hospital bill hadn't been paid. And as a result of that, the claimant filed a review and penalty petition, at which time the employer or the insurance company was aware of the fee agreement and held 20% of what was ultimately owed to the provider in escrow, and then paid the provider 80% of the balance. So the issue in this appeal stemmed from the review and penalty petition. The review and penalty petition, or the review petition, I guess, was held open. The CNR resolved the penalty. So that was held open for opinion. So those are pretty much the underlying facts of the case.
Yeah, and Lori, I don't know about your experience, but I don't think it's unusual as a starting point for a fee agreement, a workers' compensation fee agreement, to refer to percentage of medical and wage loss. I've seen that for a long time in fee agreements. I haven't seen people try to enforce it very much. Have you seen it before?
I have not.
Yeah,
I've seen it in a utilization review petition setting where the provider's involved, but not in any other setting.
I think it's one of those terms that some people have in their fee agreements, and our claimants attorney friends out there who may be watching or talked to us in the past about it. There's a lot of language in the fee agreement that hopefully never becomes an issue. There's an hourly rate that's quoted if they get fired and somebody else gets involved. And I do know that some attorneys put in their fee agreement percentage of medical. I haven't seen a claimant's attorney try to get that percentage of medical in this situation, which was essentially after a claim petition paying a regular bill. So a bit of a unique situation for the workers' comp judge. How did the judge hold, Lori? What was their decision?
The judge said it was not appropriate because the claimant and counsel had not proved that the fee was reasonable. So they denied the review and penalty petition at the judge level. The appeal board agreed, essentially. And then when it got to the Commonwealth Court said reasonableness has nothing to do with it, as long as there was an intent between the parties to enter into this agreement, meaning counsel and claimant. Reasonableness wasn't part of the analysis regarding a fee agreement situation.
When they referred to reasonable, were they talking about a reasonable amount for the services rendered, that 20% of the medical bill wasn't a reasonable payment to the attorney, or were they talking about an unreasonable contest quantum merit type standard? Which one was it?
Correct. The second, that, you know, it's whether it's reasonable based about the amount of work the attorney put into getting the bills paid, the medical bills paid, that kind of analysis.
And so the Commonwealth Court reversed the Workers' Compensation Appeal Board, and they held up the fee. They held up the 20% of medical fee.
Correct.
Do we know? I think it was a May decision. Was an appeal filed? Did you have any idea? I didn't have a chance.
I have not seen an appeal filed.
Okay. So this is the law of the land for the time being in Pennsylvania workers' compensation.
Yeah, it must be.
And that being the case, do you think this is something that's going to be broadly applied? Are you hearing from claimants' attorneys now who are asking, you know, where's my 20% of the $100 physical therapy bill? How broadly do you think this is going to impact the practice?
Like we discussed, I've never encountered the situation unless a provider was actually in the case, as they are often in the utilization review petition scenario. But again, I don't know if this is going to produce sort of an onslaught of litigation when medical bills are being paid, and how we handle that as defense attorneys.
Sure. I think what we have seen in the past is in the context of health insurance liens. A lot of times the claimant's attorneys will get a cut of the lien that's being paid out. In my experience, that's usually via an agreement with the health insurance carrier, not necessarily through a fee agreement with the claimant. So I guess that's one way where we have seen that in the past, but it will be interesting, because I think one thing that we had talked about is I think the providers are going to have some thoughts on this. Do you agree? Do you think the providers are going to have an interest in getting involved?
Yes, I think they have an interest in this case. They may not even be aware that why we're withholding 20% of a medical bill to pay a counsel. So I think they need to be made aware of it when insurers are escrowing that 20%, or they need to somehow it needs to be discussed with the provider. I don't know how that would work, but do you have any thoughts?
Obviously, the problem is if there's a fee agreement, and anybody who's been through the practice before knows that fee agreements are pretty standard, especially in a claim petition situation where it's a litigated claim, but then the carrier decides to pick up the injury, accept it as compensable. That fee agreement will go to the judge. The judge will approve the 20%, and the carrier will start taking out 20% of the wage loss. And most people don't spend, hours poring over the terms of the fee agreement. It's kind of, this is how we do this. The problem I foresee is if there's a case where the claimant's attorney believes they're going to get 20% of the medical, the carrier doesn't really see that in the fee agreement, and they just start paying medical bills as they should, then they've already paid 100% of the medical to the provider, and it becomes theoretically a penalty situation. So I do think to that regard, it pulls employers and carriers into the issue. I think when you first glance at the issue, you would probably say, well, the claimant's fee is their fee. It's their money. It's their medical benefits, their wage loss benefits. They can do with it as they please. If they want to arrange a fee with their attorney to get this amount of money, and they understand that they're giving up an aspect of their medical bills being paid, then go for it. But I think in that situation where the carrier has to make sure that it's okay to pay 100% to the provider, it does kind of create a situation of pause. Are you giving any new recommendations to your clients, Lori, as a result of the decision?
I have not yet, but going forward, I believe I will bring that to the insurer's attention, that we have a fee agreement here that has 20% possible fee on any medical benefits awarded. Again, I don't know if this case is going to apply to every single medical bill that's owed, like in a claim petition context where the claim petition is granted and there's physical therapy bills, there's pain management bills, there's hospital bills, and if there's surgery involved, that could be tens of thousands of dollars. And so I think knowing going forward, I think the insurance company should be notified.
Yes, I think it'll be also provider and attorney specific. I think most of our good friends who are well skilled in representing claimants in Pennsylvania, they know the providers within the industry. I think some of them would probably hesitate to take 20% from a provider who gives good medical care to their clients that they know is going to help out the injured worker. But if it might be a different situation where it's a different provider and it's expected that the 20% will come out. So I think in my cases, I'll probably seek clarity from the claimant's attorney. Are you asserting your fee in this case across the board? I want some sort of confirmation from you that if my client pays all these medical bills, you're not going to come back in 6 weeks and say, hey, where's my 20%? So I think in my own cases, that's probably what I'll do as this comes up. I'll probably have to go back and look at a few fee agreements as well. So it sounds like a small, passing issue, fee agreements, who cares, kind of boring language, contractual stuff. But I think as it plays out, it could have larger ramifications. Did you have any other final thoughts or anything we didn't touch on?
Yeah, just one final thought. The dissent in the case did kind of look at the humanitarian nature of the act and said, is this really protecting claimants? Are claimants really reading these fee agreements and understanding exactly what they're faced with? This particular fee agreement did have a provision that the claimant is aware that the provider could come back to the claimant and ask for that 20%. So if I were claimant's counsel, if I could switch hats, I'd be concerned. I'd want to make sure that my claimant understood that provision before signing the fee agreement.
Sure, because that would be, as a claimant's attorney, the last thing you want is your client getting jammed up because of a percentage that wasn't paid because it went into your pocket. That's I would imagine, I don't represent a lot of claimants, but that's probably not good for business. So I do think that most of our adversaries on the claimant side will probably handle this pretty well. But I also think it's something that we all need to be aware of, because it's an interesting change that, again, I had not seen this. I didn't see this coming. I didn't see this coming down the pipeline. It was an interesting decision that jumped out, and I think it's good for us all to be aware of it. Any final thoughts or words after that?
No.
Okay. Well, I want to thank everybody for watching the video. If you have any questions about the case, if you have any questions about this case, you should probably direct them to Lori, because she's read it, understood it. She wrote a good article on it. I've passively read it, and I've listened to Lori. So if you have any questions about this quick case, direct you to Lori. If you have any questions about Pennsylvania workers' comp, you can certainly talk to either of us or any of our friends and partners at Chartwell. And we do hope everybody's doing well. If you have any questions in general, you can throw them in the comments. You can shoot us an email, and we'll probably be back maybe next week with another video on either this or a related topic. So thank you for your time.
Yes, thank you, everyone.